Welcome to the online lectures for information security. In today's class, we'll be starting with Unit 2. Within the Unit 2, the first chapter is legal, ethical, and professional issues. Now, before we begin, we are going to identify what is actually legal and ethical. What does it mean? Law, what is a law? Law are rules that are adopted for determining expected behavior. Like laws are drawn from ethics. You can say what is law? Law, it is a collection of rules and regulations. It is going to be a collection of rules and regulations. Whereas ethics defines socially acceptable behaviors. That is, these acceptable behaviors, what are these based upon? These are based upon the moral principles, how a person behaves, moral principles and values, that are called as your ethics. So that is the definition for law, and these laws are drawn from ethics, and ethics are based upon socially acceptable behaviors. Now this ethics in turn are based upon cultural morals, that is fixed moral attitudes or custom of a particular group. Now within this, now if you disobey the law, you are liable for any penalties or even punishment. That is, if you do not obey the law, then if you're disobeying the law, then you have to pay penalties, or you might even have to go for some punishments. Whereas if you disobey ethics, if you disobey ethics, there are no penalties. Or now coming back to the law, this law, it need to be published. That is, some certain laws. What is this law based upon? You've got criminal laws, different types of law. This law, it is going to be published. That is, it is in written form. Whereas this law, it is not normally written. Ethics are not written. Now coming on to the different types of law. There are different types of law. The first type of law is called as the civil law. Now the civil law, it is going to represent the different laws that are recorded in different volumes. Within the civil law, you're going to have different values like the legal code. All the laws that are recorded under a legal code, those are called as your civil law. And these are available for review. That is, any person can see what happened within a particular case. He can review, who can review? A citizen can review these laws. Coming on to the criminal laws, what does criminal law do? The criminal law is going to address any violations to the society or any harmful behavior. That are your criminal laws. And these are, that's right, these are violation of violation or harmful to the society. And in here, any prosecution that is done for criminal laws, this is done by the state government. The next are tort laws. Now this tort laws allow an individual to seek recourse against any personal, physical or financial injury. Any personal and financial injury, you can recourse by the tort law. There are many insurances for personal insurance is there, financial insurance is there. If any violation, that is all are supported by the tort law. The next is private law. Now this private law, it is a relationship between a specific person, an individual and an organization. Like examples for private law, it can be a family law, labor law. These are examples for private law. Coming on to the public law, it is the relationship between the citizen, the employees, and different governments. Now, within the public law, examples for public law are this can include criminal administration or the constitutional law. So, these are the different types of laws. Coming on to the second topic in here is the relevant US laws. Within the relevant US laws, you're going to study the first law, that is the General Computer Crime Laws. Now, within this, the Computer Fraud and Abuse Act, this was originally found within the 1986. Now, this law, it was a cornerstone for many computer related federal laws. As by the name you can say, computer fraud and abuse of the computer, all of them, they come under this category. Now later, this CFA Act, the short form is CFA, the CFA, it was amended by the National Information Infrastructure and Protection Act. Within this, they have made many changes, like increasing in penalties. If there is any violation, there is increase in penalties for some selected crimes. Whereas this is the first act, this is the continuation for it. Whereas the next one, that is the USA Patriot Act of 2001. This is a was a modified version of the different existing laws. Within this, it provided a more broad picture of actions, and these actions, these were basically used for combating terrorism related activities. As the first set of CFA, it was based upon all the computer related fraud. The second, the USA Patriot Act, it was a modification of the existing laws and practices, and it was majorly used to combat terrorism related activities. The last one is the Computer Security Act of the 1987. Now this Computer Security Act, it was one of the first attempts. Now this was the first attempt to protect federal computer system. Now how are you going to protect federal computer system? This was done by establishing or implying some special security practices. That is, you're implementing security practices. Some policies are updated, some policies were applied so that you can protect the federal computers. The next is privacy. Now within this privacy, what is privacy? Within the ability to collect information on an individual, combining the facts, separating the sources, merging it. That is what you're doing in here. Many organizations, like in simple words, you can say they are collecting, swapping information so that they can sell this information. Now you're selling this information as a commodity. Now, when many organizations are collecting, swapping, selling this information, what do people do? These people are approaching the government for the protection of their security. The next, within the privacy, we're studying the privacy of customer information. As many people have approached the government for security of their information. So the privacy of customer information section of Common Carrier Regulation. This was one of the act. Now the specific act, it specifies that a proprietary information, propriety means the owner, the person that is owner of that information, it shall be used explicitly for providing services. That is, if you given your details for a particular application or for downloading some specific file, so this type of your personal information, it should only be used to provide services. That is sending you email updates or sending you forums or sending you blogs about for that particular topic. So this information should only be used for providing services and not for the marketing purpose. That is, you should not sell the information. It also tells you that you cannot disclose you cannot disclose the information except when it is very necessary to provide a service. That is, if suppose you are having some additional services that you have subscribed to, then that information is going to be used only to provide you that necessary services only. Now one exception in here is that if suppose a customer requests the disclosure of information, then that disclosure is restricted only to that specific customer only. That is this information, if the customer is requesting the disclosure of information, it cannot be sent to multiple people. The disclosure is given only to that specific customer only. The next is the Federal Act of 1974. Now this Federal Act of 1974, it regulates the government in the protection of individual privacy. That is, the government is protecting the individual privacy, and how it is governing that by creating to ensure that government agencies protect the privacy of individual and about a particular business, and any agencies that are responsible for that particular portion of the information, this cannot be used without any permission. And this states that if suppose any information is accessed by a government agency or any part of the information is accessed, so this type of information, it cannot be released without permission. The next is the Electronic Communication Privacy Act of 1986. Now this Electronic Communication Privacy Act of 1986, this regulates the interception of wires. That is, if suppose your communication, you're doing that is a communication is placed between a sender and the receiver, it can be via wire transmission, electronic or oral communication. You cannot intercept the data. That is any personal communication, any personal chat that is being conducted at the senders and the receivers end, that cannot be intercepted. Now this ECPA works in conjunction with the Fourth Amendment of the US Constitution. Now what is this Fourth Amendment? This Fourth Amendment, it states that it is going to provide protection from any unlawful search or seizure of any type of property. So this ECPA works with the Fourth Amendment. The next is the HIPAA. Now this HIPAA stands for the Health Insurance Portability and Accountability Act of 1966. That is this act, it was started in the 1966. Now this act, it is also called as the Kennedy Cassidy Act, or you can say this is the name or this is the name. Now this HIPAA, it impacts all health organizations. It can be based upon whether it is a small doctor, a health clinic, life insurance, universities, or any self-insured employee. This particular HIPAA, it is based upon health insurance. All smaller or big organizations that are related with health, they are following HIPAA. HIPAA. Now this act requires the organization that any organization that is dealing with any any health organization, you need to have certain policies so that you can secure the data of the patients. Now in here, this HIPAA Act, it does not provide you, it does not tell you what specific privacy, that you're going to ensure. It is just going to tell you that you need to implement security. It just tells you that security needs to be implemented. This privacy standard of HIPAA, it is going to restrict any dissemination or distribution of any private health information. That is within various series and dramas. You might have seen that people approach people that have gone for therapy, they get their personal information or what they are going through, and that can be used against them. So this HIPAA is going to ensure that this private health data, it cannot be given out to any person. Now if suppose there is, if the information need to be disclosed, it will not be disclosed without any written consent. That is the government orders or something that need, so that you have to release the patient's data, then only this data need to be released. Otherwise HIPAA protects, it restricts the health information to be used by other individuals. The next is the Financial Service Modernization Act. Now this requires all the financial institutes, that is all the institutions that are dealing with finance, to disclose their privacy policies. That is what privacy policies are implemented. All these financial institutes need to disclose that they need to be made public. Now this need to be made public so that the users get to know that their information is not going to be shared. Their personal information is not going to go public. Now this also requires the due notice to customers so that they can request that the information not to be shared with third parties. That is the Financial Service Modernization requirements. The next one is Export and Espionage Laws. Now the first act is the Economic Espionage Act, that is the EEA. Now this is an attempt to protect American ingenuity, that is of any intellectual property needs to be protected. Any intellectual property, it needs to be protected. Now this law, it was passed by the Congress government, and this law also prevents to share any trade secrets. Any trade secrets should not be shared. This is for protection and this is for preventing. The next is the Security and Freedom Through Encryption Act. Now this is called as SAFE, the Security Freedom Through the Encryption Act. Now this act, it was again published by the Congress government, and this act, it provides the guidance on how you're going to use encryption, and also provide measures to the public of how they are going to secure from government interventions, from provide public protection from government interventions. So these are the two laws within the export and espionage law. The first law, it is going to safeguard the intellectual property, any ideas, any assets, they need to be protected, and even how you're trading, though your trade secrets, they should not be sold. That is why this act was put in place. The next act, SAFE, this was also put in place by the Congress government, and this is going to tell you how to implement the encryption of the data. Now, why to implement encryption? So that you can safeguard your data, so that any people that are trying to access your data or they are trying to sell it, if they get access to it, they should not be able to, that the data should not be any use of them, because they do not know how to decrypt the data. The next is the US copyright law. Now this copyright law, it says any intellectual property, that is any ideas, are also called as your, these ideas are also called as your assets. What are asset? Asset is anything that is going to provide you value. That is a specific idea. If you're implementing a specific idea, it can be good for your business and it can increase the profit. So that idea is your asset. That idea is going to provide you value. So intellectual property is recognized as an asset, and this needs to be protected. Now, there are some fair, how you can use the fair use of copyright material. It includes that some support news is there, or some teaching material is there, or it is used to be for scholarship. Then this type of data is the fair use of copyright material. Or for the purpose of educational or library purposes, if you're using some type of data, then that data can be used, not for profit. The next is the Freedom of Information Act, that is FOIA. Now this FOIA Act, it provides any person with the right to request access to federal agency records or information. That is, if there is any citizen, he needs access to some specific records from some specific time. That is, if suppose a person wants access of his grandparents' records, where they used to stay, something like that. So he can request the access to the federal agency records for information. And some records, they can be hidden. Suppose they are of national security, then those records will not be disclosed. But if suppose you want access to any some specific type of information, then that request is granted. Now this US government agencies are required to disclose any requested information on receipt of a written request. That is how you're going to, disclose the information. If one person comes and asks you, you're not going to disclose the information. You need to have a written request from the officials. If you show that written request, then only you'll be given access to that specific information. Then the next one is state and local regulations. Now within the previous slides you have studied, there are some specific national and international restrictions that are placed upon the organizations. Now this is for the use of computer technology. Now each state or locality may have some different number of laws and regulations and the impact operation. That is, each and every state might have their own set of rules and regulations. Now it becomes the responsibility of the information security person, the person that is going to provide you with information security. He needs to understand what are the different state laws and regulations, and he need to ensure how he is going to comply with these laws and regulations. Because violation of any type of law, it, you might have to pay penalties, or punishments can also be given. So this is the end of the class.